The Office of the Chief of Army Staff and that of Attorney General of the Federation and Minister of Justice have criticized some of the provisions of the proposed National Human Rights Commission Repeal and Reenactment Bill of 2020. The Nigerian military faulted sections of the Act establishing the National Human Rights Commission (NHRC) that gives its power similar in force with those of high courts in the country. TV360's Timisola Adigun tells us more.
It is a public hearing on the Repeal and Enactment Bill 2020 of the National Human Rights Commission, organized by the Joint Senate and House of Representatives Committee on Judiciary, Human Rights and Legal Matters. The military, among other issues at the event, asked that powers given to the Commission be reviewed by the Parliament, as the Commission will possess powers as much as the High Court in Nigeria.
Judicial powers are vested in courts and other tribunals in Nigeria only by virtue of the provision of Section 6 of the Constitution of the Federal Republic of Nigeria. It will also amount to travesty of justice if the investigating body determines the complaints and makes same enforceable, as it is a principle of justice, and no man shall be a judge in his own cause. The lawyers here no nemo judex in causa sua. It is also against the letters and spirit of Section 36(1) and 4 of the Constitution of the Federal Republic of Nigeria, which guarantees right to fair hearing before an impartial tribunal or body.
Permit the denial of an application for any information, disclosure of which may be injurious to the defense of the Federal Republic of Nigeria, or disclose the identity of a confidential source as well as information which could compromise the security of the nation. Thus, the proposed Section 6, Sub 4, Paragraph A of the Human Rights Act could be amended by adding the clause, except where such disclosure is not permitted by law or court order.
The Commission should be encouraged or should be directed to synergize with the institutions that may be operating those laws, because some of these institutions have peculiarities that their laws set out to address.
The military also faulted the exclusion of the armed forces, the DSS and the police from the Governing Council of the NHRC. In his separate submission, the Executive Secretary of the National Human Rights Commission, Anthony Ojukwu, said there is need for enabling legislation to better reposition the Commission in the face of worsening human rights records.
If government of Nigeria really wants us to be effective, the issue of this human rights fund should not even be negotiable, because all the companies were asking to make contributions. Are they not supposed to benefit from a peaceful climate to conduct their business and make profit?
Specific provisions were made in the bill to provide for the establishment of the National Human Rights Fund in the national budget, and as well provide effective means of sustaining contribution to the fund, whereby non-governmental organizations and multinational corporations are expected to make remittances accordingly. The initiative for providing for the fund is in line with global best practices as it relates to human rights institutions worldwide.
The bill under consideration seeks to harmonize the National Human Rights Commission Act of 1995 and the Amendment Act of 2010 to, among other things, enable the Commission to conduct investigations and sustain contributions to the Human Rights Fund. Timisola Adigun, TV360 News.